Hello friends, welcome to my channel. Friends, in today's video, we will talk about data protection officers. Section 4 under Article 37 to 39 of GDPR talks about data protection officers. Now let's understand who are data protection officers. Data protection officers, commonly referred to as DPO, is an individual who is designated by an organization to ensure GDPR compliance by that company or organization. The primary role of a DPO is to ensure that their organization processes the personal data of data subjects as per guidelines and directions under GDPR. This is one way of showing accountability to the data subjects and convincing them that you are serious about handling their data responsibly. And that's why GDPR provides under Article 37 that a DPO should be capable of performing the tasks expected under GDPR and hence should be well qualified to handle the responsibilities that come with this designation. Now friends, let's look at the qualifications of a DPO. GDPR does not mention any specific qualifications. However, certain qualities and expertise have been stated which are expected to be possessed by a DPO or a data protection officer. Number 1, knowledge of data privacy and data protection, which is a very common and a normal consequence. A DPO should have excellent understanding of GDPR and familiarity with the rights and obligations and all the principles which relate to data privacy in respect to the national and local data protection laws and regulations. Number 2, significant, that is minimum 5 years of experience in legal and regulatory frameworks relating to data protection and privacy laws. Number 3, significant experience working with IT programming or infrastructure. Number 4, a DPO must possess excellent organizational and communication skills to be able to address the needs of different audiences and communicate complex data protection concepts to both technical and non-technical individuals within the organization with ease. The types of audience could vary from data subjects to employees to specialists to lawyers to the head of organization like the CXOs, CEO, CTO, etc. So basically, address different stakeholders with clarity and ease so that they can perform their tasks effectively. Number 5, a DPO must be capable of performing their tasks independently and responsibly without any conflict of interest. Now friends, a recent judgment by the CJEU, that is Court of Justice of the European Union, which is very recent, 9th Feb 2023, in the ex-FAB Dresden case, it's a case from Germany, addressed the question of what determines conflict of interest under Article 38 of GDPR. Now CJEU clarified here the criteria for assessing whether a conflict of interest exists between the DPO's position and other tasks or duties that are assigned to the DPO. Now this problem arose because GDPR says that the DPO can hold any other role in the organization along with their current DPO role, but the condition is that conflict of interest should not arise. Now the court in this case stated that the DPO should be in a position to perform their duties and tasks in an independent manner, but they cannot be entrusted with tasks or duties which would result in him or her determining the objectives and methods of processing personal data on part of the controller or its processor. So basically, the court stated here that the task of a DPO is to monitor and ensure the data controllers and data processors comply with data protection laws and the relevant policies under GDPR. And therefore, a DPO needs to be completely independent and should not hold any role or position in the organization where he could influence the decision about the purpose or the means of processing data. Some of these positions could be the CXOs, that is the senior executive management, the head of HR, head of legal, etc. The CJEU also stated that whether a conflict of interest exists in any case will be decided by the national courts of that country on a case by case basis. But the fact that no conflict of interest should exist has been upheld by the court in this case. And friends, the last one. The DPOs should be able to stay updated on latest emerging trends or any change in the data protection regulations, etc. They should be able to adapt quickly to the ever changing and evolving technologies and adapt in a way so as to ensure compliance with the data protection requirements. Now, friends, we know who are data protection officers, what are their qualifications. Now, let's understand when data protection officers are supposed to be designated. A DPO shall be designated by data controllers and data processors under the following conditions. Number 1, public administration, where the processing is carried out by a public authority or body, except courts while they are working in their judicial capacity. They need to appoint a DPO. For example, ministries, government agencies, local bodies, etc. Number 2, those cases where large-scale data processing happens. That is, where the core activities of the controller or the processor requires regular and systematic monitoring of data subjects on a large scale. For example, banks, financial institutions, telecom companies, e-commerce companies, etc. So friends, here the determining factor is core activities or main activities. If the main activity of an organization is to perform data processing on a large scale for the purpose of their business, a DPO is mandatory. And the third case, large-scale processing of sensitive or special data. Now here the core activities of the controller or the processor consist of processing special categories of data as specified under Article 9, for example, religious beliefs, racial origin, genetic data, biometric data, different kinds of memberships that people hold, their sexual orientation, etc. Most of the institutions which hold this kind of data are the schools and the universities. And therefore, if they process a data of this nature on a large scale, they need to appoint a DPO. And the second is the case where the organization processes the personal data as per Article 10, which relates to criminal convictions and offences or security measures. For example, police department, national security agency, they hold and they process data on a large scale for the various criminals and offenders, and therefore they also need a DPO. Friends, I hope by now it is clear that GDPR mandates a DPO depending upon the type of data and the amount of data that any organization processes. And the size of the organization is not of much significance here. So those organizations which do not handle large-scale data or those which have an in-house counsel to address these matters don't need a DPO. For example, law firms. Those law firms which are processing the personal data of their clients or a community doctor providing medical services in and around their community don't need to appoint a DPO, but they still have to ensure compliance with GDPR. So friends, based on what we have learnt as of now, it is better to appoint a DPO in case you are doubtful or in case you process large-scale data, or it's better to seek an advice to have clarity as to whether you need a DPO or not. And if you choose not to appoint a DPO, I would recommend you to really record a very reasonable and detailed response as to why you are not appointing a DPO, so that you are in a position to respond to queries by the data authorities in case they expected that you would appoint a DPO and you haven't. Now, friends, I would like to mention two case laws here where companies have been fined for not appointing a DPO. The first case is the Glovo case. Glovo case is a Spanish case that was initiated in 2019 and decided in 2020. Now, the case was initiated on a complaint by a Spanish citizen that Glovo does not have a DPO to address any complaints that arise regarding their data protection. Now, friends, Glovo is a Spanish on-demand courier services that picks up and delivers orders that are placed through a mobile app. Now, when this case was initiated, Glovo stated in its defense that since they did not fall under Article 37, they had no need to appoint a DPO. Secondly, they also stated that they had a data protection committee and therefore no DPO was necessary. But once the proceedings were initiated, that the complaint against Glovo was initiated, Glovo did appoint a DPO. So the Spanish Data Protection Authority, AEPD, recognized and appreciated that Glovo made this change, but still it did not deter them from imposing a fine of 25,000 euros on Glovo for failing to appoint a DPO as per GDPR. The second case is the Hamburg Data Protection Commission's case, where they imposed a fine of euros 51,000 on Facebook Germany GmbH, that is Facebook's German subsidiary, for failing to notify the appointment of its DPO. The Hamburg authority said that fine was necessary to ensure that organizations comply with GDPR's data protection requirements. So friends, any organization that processes large-scale data and falls under the umbrella of the provisions which mandates the appointment of a DPO and fails to appoint one, then the GDPR states with full clarity that they will be subject to fines and penalties. Therefore, friends, it's best that any organization that handles data must do a clear assessment in this direction in order to avoid incurring liability, which could be easily avoided by simply appointing a DPO or having full clarity as to why they do not need to appoint a DPO. Now, friends, a logical question: how many DPOs need to be appointed? GDPR specifically states that a data protection officer must be designated under Article 37. So when we look at the singularity of the use of the term DPO, it can be presumed that one single DPO must be there so that this DPO becomes the single point of contact for authorities or data subjects who can directly get in touch with this person as regards any query that they might have concerning data processing. Now, whether this DPO will overlook one organization or many organizations is a flexibility that has been provided, but it is important to ensure if a DPO is looking after a few organizations that he is or she is sufficiently accessible as a DPO to all these organizations. GDPR also provides that if there are a group of companies which are under the umbrella of a controlling company, then one DPO can be appointed to look after all the companies under that umbrella. But again, the condition is that the DPO should be capable of providing sufficient accessibility to all the organizations. Now friends, let's look at the responsibilities of a DPO. The main responsibilities of a DPO are: number 1, handling requests. A DPO receives requests from data subjects all the time. For example, to access their data, to erase their data, to rectify or change their data, or sometimes to receive comments and questions related to the processing of data subjects' data. Handling those requests, responding to those questions is mandated under GDPR. Number 2, advising. A DPO has to inform, guide, and advise an organization and its employees as regards data protection obligations under GDPR and also any other relevant provisions which are applicable to their organizations under the EU member state data protection provisions. It's worth mentioning here, friends, that the national data protection regulations of different countries of the European Union could be slightly different from GDPR. They could be a little bit more stricter. That flexibility has been provided to the member nations by GDPR. Number 3, compliance. A DPO has to monitor and ensure compliance by the organization under GDPR and any other applicable EU member state data protection provisions. Number 4, DPIA, that is very simple to perform data protection impact assessments. Number 5, liaising. DPO is the main point of contact for the main data protection authority of a country or a state and must cooperate with them as and when need arises. For example, reporting data breaches, assisting with investigations, and responding to inquiries from regulatory authorities. Number 6, training. A DPO is responsible for informing and training the employees of their organization as regards the data protection obligations of that organization and also to ensure that a culture of privacy and data protection is maintained throughout the organization. So friends, the primary aim of a DPO is to ensure that organizations process personal data of data subjects in a lawful, transparent and responsible manner so as to ensure that the right of privacy of data subjects is respected and upheld at all times. So friends, I hope this video gave you a nice complete overview about the DPOs, their roles, responsibilities, why they need to be appointed, and what happens if an organization fails to appoint them with the help of a few case laws. So friends, I hope you liked the video. Thank you so much for your time, and I'll see you soon with another video. Till then, goodbye, take care, and have a great day.